Welcome, everybody, to Catholic Owned Live. I'm your host, Brooke Joyner, and today we have an extra special show, so we hope you'll tune in and join us here today for the show. Catholic Owned Live is a show where we talk honestly about faith, work, vocation, and what it really takes to build the new Catholic economy. Today, I have a very special guest with me, and I will introduce her now. Susie Hickson Bledsoe is a trademark attorney and the founder of Hickson Law PLLC. She works with founders, creatives, and mission driven companies worldwide to protect and steward their brands for long term. With more than 2 decades of experience, she helps clients move beyond just filing and build durable intellectual property strategies that support sustainable growth. She currently serves as chair of her parish pastoral council, where she supports spiritual leadership and long-term institutional stewardship as well. Susie, thank you so much for being my guest today.
Thank you for having me. I'm so happy to be here. And I was thinking about your trademarks earlier and how much I love building the new Catholic economy, because building really is the right word for kind of what we're doing here, right? We're just not decorating ordinary businesses with Catholic language. We're trying to build something durable and trustworthy, and really ordered towards the good.
Mm-hmm. Absolutely. Well, and you, Susie, have been a longtime member of Catholic Owned, and of course, we have just loved working with you as our trademark attorney and sort of guardian of our brand. And I would love to share a little more about that in our conversation as well. Because I've just come to understand the importance of that through working with you more and more every year. So, but I would love to really shine a light and talk about some of these topics that I think in the Catholic world uh, have this particular sensitivity. The idea of brand equity and the value that we're creating in this very high trust economy that we're trying to build.
Yeah, I think that we have to keep in mind that a Catholic business is still a real business, right? You need clarity, quality, follow through, and sound operations, just like any other business. And your faith doesn't excuse sloppiness around the business. And if anything, it really raises the bar. So your Catholic identity and how it works around your business, no matter what it is, really should deepen that responsibility, and not really become a shortcut around anything.
Absolutely. It really does matter. And I guess, of course, this is related to our trademarks, but it's that idea of what does it really mean to be a Catholic owned business?
Yeah.
And it just comes with so many additional responsibilities, which I think you touched on. Can you share a little bit on in terms of your expertise on that idea of trademarks, why they matter, and why protecting them is so important for businesses in this space?
Yeah. So what I like to really tell my Catholic businesses is that your trademark isn't just a legal asset; it's a vessel of trust, or kind of a vessel for trust. And trademarks exist, and the protection or the allowance of the protection of trademarks, from a federal government perspective, is not just to help brands build equity and their own businesses. The whole concept partly exists to protect consumers. So, trademark protection isn't just about ego. It's just not about vanity. It's not about you wanting to own everything for your business. You have to really keep in mind that a brand is really one of the main ways that people, they find you. It's how they learn to trust you. It's how they learn to come back to you. It's how they learn to recommend you to their neighbor. And really in our space, I feel like word of mouth marketing amongst the communities is really one of the best ways to grow. And you can do, if people don't know the name of your business, it's maybe harder for them to share your products or services. And if you've built goodwill around a name, or trademark, there really is a stewardship of responsibility to protect it wisely. And one of the ways of doing that is going through that trademark application process, which can be a little daunting. I try to make it as non-daunting as possible, but it exists for a reason. I gave two big reasons actually that to help businesses build brand equity, and then also to help the consuming public to find you, right? But as you know, Brooke, trademark filing is not the finish line. It's kind of just the start.
Oh, and that's absolutely true. And we've been doing this a long time, and we should definitely get into what I think and what I really appreciate about you is the monitoring and enforcement and really that long-term brand care, what that looks like, from the Catholic perspective, because we can do that in a lot of different ways. And but before we get into that, I really want to help people and just talk about the idea of brand equity. I think it's easy to just brush that off, but really, I mean, building a brand is it's a very expensive, it's a very time consuming, it's a very, and there's a lot of heart that goes into that. And, I know we have brand specialists. That's their whole thing. Their whole thing is to build a brand for you.
Right.
And that is such a beautiful skill, and we love those members. But once that brand is built, it has to be protected. And really, I think for the Catholic businesses, so many of us, this is really a mission. And so when you're talking about you've been called by God to do this thing, you invest to build the thing, you invest to have the brand be created and crafted in this beautiful way. It's almost as if you have to protect it. It seems only logical.
Yeah. Yeah, it goes back to what I was saying about, the brand being the vessel of trust. And when people see that brand, it will, well up a certain type of emotion in them. Think about when you see a BMW logo, right, on someone's car, you're going to have some type of feeling or emotional reaction to it. When you go to the grocery store and you're trying to decide what type of food that you want to buy under what brand, there's always going to be an emotional attachment to it. And I think that's totally understandable as consumers, but at the end of the day, that is the goal of the brand owner. They want to kind of impress that emotional response from the consumer. It's like a brain tattoo. It's how people remember you when they see that that text element, or maybe the design logo. They think of the source of where that particular product came from. So getting it something like that registered, again, that's really just half the battle. I mean, there is the monitoring of your brand, because if you don't monitor it, you don't know what potential conflicts are out there. You don't know if somebody's talking about you. You don't know if someone is taking your brand name and trying to change it just a little bit to intentionally confuse people. That's kind of what we were talking about earlier. That's pretty rare. I mean, people, when they infringe, most of the time it's an accident. But as a brand owner, you do have responsibility to the consuming public to correct what you see to correct what you see out there, and that includes infringement. And I tell my clients, or people that I work with, a lot of times they come to me and they've already been using a trademark, and they don't know if they should file it or not, and because it's not cheap, right? You have to pay money to get the registration. But I tell them, are you ready, willing, and able to enforce it? Right. And so that means, do you have the funds to enforce it if you need to? And do you have the gumption to to enforce it? I've had situations where people are like, I feel weird. I feel so bad about enforcing my mark. And it's like, well, there's no point in getting the registration unless you're stewarding your own mark, unless you're taking care of your own brand, because that's part of the battle. And you mentioned the equity in the brand, right? There's going to be money spent on filing. There's money spent on the marketing, and there's potentially money that's going to be ultimately spent on enforcement. And the level of enforcement, as we've talked about quite a lot, really comes down to kind of a case-by-case basis, about how aggressive you really need to get with someone. And a lot of times it really does come down to an innocent mistake.
Well, and I think that's so important because, we were just chatting offline, and you shared something really interesting about when people really are even starting the filing process. When someone, if we just take it back, someone has an idea for a business or a brand name, they come up with it. They feel it's original to them because they came up with it. And can you share, I guess, what are some of the best practices for a business owner, an aspiring entrepreneur who says, hey, I have this idea, I want to use this term. What should they be doing when looking at trademarking their terms and marks?
Yeah, so the first thing I'll talk a little bit is about trademark strength. And there's sort of this, what's called a spectrum of distinctiveness when it comes to trademarks, from marks that are really distinctive on their own to marks or terms that are basically descriptive or generic. Really distinctive marks are oftentimes coined terms, like Exxon, EXXON, for an oil company. Portmanteaus, which are word mashups, are also really strong trademarks, and I strongly suggest people consider them. An example of one is Travelocity, where you have the word travel and velocity, and they kind of allude to what the underlying product is. Another example of a really great, one of my favorite trademarks, is Pup-Peroni, and it's for dog treats. So you have the word pup and pepperoni, and they're kind of mashed up. Again, portmanteaus, those are strong marks. You start getting to marks that are what are called arbitrary. They're a little weaker. And arbitrary terms are words that are real words, but there's no relationship to the underlying product. So an example of that would be Apple for computers. And then you get into terms that are a little more descriptive, and people really love these because they're like, well, I want to use this term to describe my product or my service. But they have to be careful there because the USPTO takes the position that they won't grant a registration for terms that anyone should be able to use. Now, there are ways around this, as we know. There are arguments that you can use. You can amend an application to the supplemental register. So descriptive terms, I shy away from them. I encourage my clients to try to pick more distinctive marks than descriptive terms, but sometimes they're already down the road of having used a mark that's descriptive for a while, and then we'll go ahead and file it and try to get it through to registration. The other thing that I want people to think about when it comes to selecting a trademark is, not only is whether or not it's distinctive, but whether or not it is available for use. Is anyone else out there using it, or do they have it registered? So it's always really good to do conflict searching before you file. And there's some different methodologies here. AI, ChatGPT is not one of them. In January or in June of 2026, I should just preface, do not use AI, ChatGPT. Don't use that right now for clearance searches. You still need to go to the USPTO. Again, clunky, but there are also other platforms that you can hire a trademark lawyer to help you with in terms of more robust screening searches. And I recommend you do that before you spend much money on trademark application, and before you spend a lot of money on marketing under a mark. I'd like to tell my clients, like, start out low in your marketing. Like, you don't need to start $100,000 marketing campaign. Like, brands grow in value over time, and that's okay, and that's good, right? So, as you become more confident in your use of the mark, as you become more confident in the registerability of your mark, as you become more confident once your mark gets registered, as you get more confident in the fact that you have gotten it, you filed the appropriate documents with the USPTO to show that your mark, is now incontestable. Like, there's certain steps along this process that help you grow, strengthen the mark. I might have gone off a little bit of a tangent there, but that's helpful.
No, that's okay. That's great, because it can be hard to know even where to begin.
Yeah.
Right. And I think just that searching is so important, that especially before you sink a lot of investment into building a brand, making sure that term is available is a really wise first step.
It's really wise, but remember, like, there's never really ever a slam dunk. You know what I mean? Like, even when you think you're like, oh, this is a slam, don't ever think it's a slam dunk in terms of registerability, because in the US, we honor common law rights to marks. So it's always good to know what's being used just out in the wild, and not just what's filed at the USPTO. Mm-hmm. And that's why the monitoring is so important, that I was talking to you about earlier.
Mm-hmm. Well, and the other piece that I know you really have just been you inform us so well, but an interesting thing I've heard other people confused about is in regards to the classes of protection.
Yeah.
And this is one reason I always refer people to you, because first, they don't know about the classes, but second, I really feel like having a qualified attorney get to know your business, get to know the big vision, and then very intentionally choose the classes to file for is such a huge value and a wise strategic move. So can you share with us a little about the classes, and why does that matter in this whole conversation?
Everything around me, including services, veterinarian services. I have my dog here, so I'm thinking of veterinarian services. Everything that you can imagine, products and services, all fall into 45 classes that have been kind of defined by the NICE, which is the International Filing System, and the U.S. Aligns itself with that. So when you file a trademark application in the U.S. or even internationally, you have to say what your goods are. If you are selling pillows, they're going to fall into class 20. Mattress pads, I think, fall into class 24, which is kind of weird because you would think that they would fall together, but it's just kind of some weird, classification rubrics that are going on. So where this really becomes important, and where it might not bite you initially, but may eventually, is that you do have to show the USPTO that you're using your mark in commerce for the applied for goods and services. So sometimes they're like, well, we'll file this application on an intent to use basis, and we'll later on provide that information to the USPTO. Well, when it comes time to provide that information to the USPTO, 6 months, a year down the road, they've filed in the wrong class. Their specimens or their actual examples of use don't file for, they don't align for what you actually filed for. So I see this unfortunately happen a lot. The other thing that I see happen with respect to these classes, which I mean, we could do like an entire, do you want to do an entire like seminar on classes? It's insane. One thing that I see happen, and I see this more now because I've been practicing for 20 years, but I see drift. And so people file for CDs in like 1995, right? And then here we are up for renewal of their registrations, and they're like, we don't even do CDs anymore, you know? So you get drift amongst those from those classes. So that's what's important to, I think, if your trademark attorney is like, hey, let's hop on the phone this year, like let's do an annual brand review and let's make sure that your use is aligned with how we filed it, right? Or do we need to look at filing a new application, right? Those kinds of check-ins with your lawyers, like don't ignore us when we're don't ignore us, Brooke. No, Brooke doesn't ignore me. But those brand reviews are sort of like an assessment to make sure that your use continues to stay aligned with how it was filed in a particular international class. Now, you can't go back and revise an application or a registration. Now they'll let you narrow your goods, but they won't let you broaden the scope of it without filing a new application. So Brooke, if you came to me later on and you said, hey, we want to do newsletters, I can't be like, oh, we'll just throw that into the current registration, right? I would say, okay, we need to look and see if it's worthwhile to file an international class 16 for newsletters.
Mm-hmm. Well, and I think that, and kind of what I was saying about your trademark attorney of choice, listening to the vision of the business, I think for us, and obviously we're kind of an interesting business, it's different, but I think having an attorney that, like you have an entrepreneurial mind, and you're obviously very well versed on all of the applicable intellectual property topics, but you also have a good understanding of entrepreneurship and community and economics, and that made you the perfect match for us, because I mean, it's kind of funny looking back. It was almost, just from what I shared with you, it was almost as if you understood the business better than I did at that time. So now as we're growing, it's like, wow, she really understood the vision and was proactive in selecting the classes that we would need protection for. And I don't think that just any trademark attorney would do that.
Appreciate that. Yeah. I mean, honestly, most of my clients are working from a budget. So as we all kind of are, right? So, I like to kind of dig into the business and figure out, well, what makes sense for them to file first? Because at the end of the day, arguably, for many businesses, you could end up filing in at least 5 international classes. And the reason this is important, and the reason you got to strategize and prioritize, is because the USPTO charges you a fee for every single class that you file in, right? So you want to be strategic, and 99% of us need to be strategic in terms of where we're filing. So I think that at this point, I'm pretty good at helping clients prioritize what makes sense to file first, and maybe, look at certain things like, I don't think we need to file for newsletters and t-shirts and mugs and and lanyards and keychains and right, all of the things, because at the end of the day, people are like, let's file for, and I'm like, no, that's just, it's like just advertising collateral. Like we don't need you don't need to worry about that right now. So yeah, that's kind of part of the thing about working with an attorney who does trademark work. Okay, yeah. Don't work with Bob who does the family law stuff. Okay,
Right.
I can't do family law stuff. Like don't even. Do you need to get out of a traffic ticket? Don't come to Susie. I cannot help you do that. So even attorneys that have less experience, but as long as they're trademark attorneys and understand kind of those nuances and the importance of proper classification of goods and why it's important to not file, why you don't need to file for necessarily merchandise, right? You don't need to file for t-shirts because it's advertising collateral. Let's not waste our time on filing specimens that show our trademark really big on the front of a t-shirt. That's not trademark use. Trademark use is labels and hang tags, right? This is the big use of your fun logo on the front of your t-shirt. It's awesome, but that will not be accepted by the USPTO. And if you don't do this kind of work, you're not gonna know that. And that's okay. Like, but why would you? Right? My point really is, the thought of spending money on a lawyer to do this kind of work can be like, you don't want to do it. But it is the same song and dance over and over, Brooke. An ounce of prevention is worth a pound of cure. It's so cliche, and I say it all the time, but it almost never. It seems like it always rings true. It just always rings true.
Well, and I think that's the perfect lead into the enforcement conversation. I think this, in several groups, Facebook groups and stuff that I'm in, I feel like in recent years, the enforcement conversation has really had more attention than in previous years. And one thing I love about working with you is your approach to enforcement. And I think as a Catholic brand, when we're talking about enforcing trademark rights, it is so important to have the right approach. So can you talk to us a little bit about that and how it's almost a dance, how you approach it?
It is, and every situation is different. I remember though looking about or really kind of learning about the nuances of enforcement, like maybe 50 years ago. And because that's kind of when I started getting in, when I was working at a larger firm, I started getting in more to the enforcement and litigation side of the work. And I remember that company Jim Beam had gotten a enforcement letter. They had sent an enforcement letter to someone who was infringing their mark. Kentucky, Tennessee, we all have our liquor brands, right? But the enforcement letter was so nice. And it was like, we're so honored that, you enjoy Jim Beam. It was like the nicest enforcement letter. And that enforcement letter went viral. And I mean, viral for, I don't know, 2005, whenever this was. Or maybe, like kind of late. It was between 2005 and 2010, I think. And it went viral. And, they got some really good PR from that demand letter. And that really taught me, you got to be really careful about demand letters because, of course, going viral back then is even way different than it is now, right? But you have to be very careful because whatever you put out there, someone can post it. You don't want to be accused of being a trademark bully or overly aggressive, no matter what business you're in. But it's even kind of more challenging when you're in a Catholic space, right, or a Christian space, because you're like, well, I got to be even more careful, right? But it doesn't take away from the fact that there are consumers out there that you have to protect too, and it does feel like kind of walking a fine line or kind of threading a needle, right, in terms of the enforcement and being kind and kind of saying, hey, I'm sure you kind of didn't mean to do this, but we owe we have the responsibility to the consumer to not allow confusion in the marketplace, and therefore, you need to change, you need to remove this term. And I think, most of the time they do. If you feel like you need to escalate, then you can escalate. And and this is something we talk about a lot. Do you get a lawyer to do it, or do you try to work it out amongst each other? Getting a lawyer to do an enforcement is escalating. I usually say, unless it's really, really egregious, reach out to them, start a conversation. Maybe there's could be some good collaboration going on. That's what I've learned more and more, is that you can eventually get some really good partnerships and collabs out of these types of mishaps, rather than like sending the big nasty legal letter. And even if I do, demand letters, mine are never. They're very factual, non-emotional. This is what's happening. This is what we have to do. This. Please change your branding. So I don't know. I hope I touched on some things that you found helpful.
Absolutely. Well, and I think, yeah, I think that it kind of comes back to that stewardship of the mission, that stewardship of the brand. I sometimes relate this to having to, I'm a mother and having to correct a child. That's uncomfortable. That's not natural for me. I don't like that. But sometimes we have to say, hey, look, this is not okay. And how do we work this out? And I feel like your approach is kind of similar to that.
I'm probably one of the least confrontational attorneys. Like I'm sort of like you. Like I don't have children, but I always hated reprimanding my niece or nephews. It was like, I hated that, And but yeah, I mean, you if you can just try to pull the emotion out of it and just keep things very fact based about why it has to be done. I think that makes those enforcement letters a little bit easier. And again, like I said, if you can work that out amongst yourselves, that's usually the better situation. Again, once you have your lawyer do a demand letter, they're going to go get their lawyer. Like the lawyers are going to be like, and then you want to try to avoid that as much as possible.
Yeah, for sure. And objectively, because the enforcement, when people, that's never happened to me, but the way I think about it is, if people want to be confrontational, they want to get the attorneys involved. It's like, what value is being created? There's no value being created. There's just resources being poured into this disagreement. And I think when it gets to that, the person who's unwilling to cede is it is ego at that point.
Yeah, 100%. Yeah, I mean, it's interesting because you deal with the ego in all businesses, right? Like Catholic businesses have ego too. I've seen them out there. But yeah, I mean, you do see a lot of that. You see a lot of that. People get that emotional attachment, or I want to win. And it's like, yeah.
Yeah. And it's kind of sort of the ugly side of humanity, right? We all have it, but it's an interesting thing. So, but I think generally in our experience, people, like you say, and as you've taught us, giving people the benefit of the doubt of, it was probably an accident, and just having that gracious approach, which is like so aligned with our Catholic faith, honoring the human dignity of the other person and what they're building, while also stewarding the mission God has given you. It's a beautiful process when done well. And I think that's why it's important to have the right trademark attorney on your side, because if one is kind of that confrontational approach that's going to dictate a lot, right?
I think so. I mean, I don't know. I think people wonder whether or not protection and enforcement of trademarks is contrary to generosity and mission. But I don't think that it has to be greedy or combative, right? It means being responsible with something, your brand, that people have come to trust your brand. So, you do have that responsibility to the consuming public to enforce, but in a very nuanced way.
Absolutely, absolutely. And you really do strike a great balance. Is there any other, I guess, general information about enforcement that you wanted to make sure and cover? Because I know you do a lot for us, you do a lot for all your clients. So there's a lot to enforcement.
Yeah, enforcement is
as well.
It's sort of its own animal, right? I mean, because you go through the trademark application process, and that lasts about 6 months to a year and a half if it's smooth. But the enforcement is a whole other animal because it's constant. As soon as a company starts using a mark, really they need to be monitoring it. And when I say monitoring, there's different levels of monitoring. One is sort of your most basic, like you do it yourself. You put it on Google Alerts, and then you put it in your calendar, like as a little reminder, like once a month, go to the USPTO, check Amazon, if you're a product, check different platforms, check social media, just kind of your own searching. Of course, if you want something a little more robust or up level in terms of monitoring, you can do monitoring of applications that are filed at the USPTO and applications that are published, marks that are confusingly similar. And I suggest using software for that, because it would be crazy trying to do that searching on your own. And the thing about searching, the monitoring software or a watch, you're poked. You get an email whenever a conflict pops up, so you're able to look at it rather than having to get into it every single month. Of course, there's even more aggressive monitoring, and that's more of a comprehensive monitoring. If you feel like you need to monitor internationally, that's an option. If you have a mobile app, there's platforms for doing mobile app monitoring. So there's a lot of different options when it actually comes to monitoring. And the reason I'm mentioning that is because it's sort of the first part of enforcement, because you don't know what's out there, right? Unless you're proactively monitoring. Of course, there are situations where people send you an email and they say, "Hey, Brooke, I just came across this," and you have your hall monitors out there that
right.
that report, and you love it. You're like, "Whoa, thanks," because I would say, maybe 25% of the marks that we find out about or the conflicts come from the hall monitors. So
it's true.
So, but you don't want to always depend on the hall monitors, right? So you want to think about, if I'm doing my own monitoring, am I doing it consistently and regularly? Am I searching for spelling or am I monitoring spelling variations? So if your mark has the word 8 in it, EIHT, you should be monitoring ATE, the number 8, right? Like you should know, because even though they're a little different in terms of whether there could be a conflict, there could still be a conflict, because it's would the consuming public be confused? And the USPTO takes a very low bar here in terms of likelihood of confusion, right? It's like, would a 3-year-old be confused? Okay, yeah, right. So would a 3-year-old be confused with EIGHT and ATE? Possibly. So that's kind of with the consuming public, are they likely to be confused as to the source of this trademark? And so that's kind of where I'm getting at with the benefit of that more robust monitoring or watching is that it's able to do that thanks to technology. Just things that it would just take us as humans far too long to do truncation and different iterations and spelling variations for monitoring.
Mm-hmm. Well, like you said, monitoring is the first step of enforcement. So it's all part of that stewardship of the brand.
Yeah.
Really.
It really is. Yeah, it is. If you can look at it as stewardship, right? It's taking care of your brand. And, to some extent, once the trust factor is attached to your brand, there's that element of protecting the consumer too.
Mm-hmm, mm-hmm. And that's such an important focus too, that we're trying to protect people other than ourselves in this.
I should go back a little bit too and say that if you do not enforce your rights, and have that record of enforcement, there's the possibility that your mark can be subject to cancellation for failure to enforce. So, that's part of your duty as, the USPTO kind of grants you this right. And as part of that, the ownership, the registration, but as part of that, you have the right to enforce. You really need to, I shouldn't even say right, like you have an obligation to enforce. And again, though, it comes down to, how aggressively do you want to do it? Very seldom do matters really escalate to full-blown oppositions. I've been doing this for 20 years, and I've had a handful of matters that have gotten so escalated that I had to send it to a litigator. So not too bad though for 20 years.
Right, for 20 years, a handful is not bad.
The goal is to settle. The goal is to win. I mean, I don't know. I mean, everyone has their kind of own goal and their own motivation, right? So it's always, what is the goal here? And that's something I always ask clients. How aggressive do you want to get here? This person has a USPTO filing, but they're also using it. Does this demand letter need to address both the application and the common law use of the mark? And it usually does. So
yeah. No, I'm so glad that you mentioned that. It is you're agreeing to enforce it when they grant you that right. So
yeah.
Well, this has been just wonderful, Susie. You're just such a wealth of knowledge, and I always, thanks to you, I at least have a basic understanding of some of the matters here. So when I, speak with people, because generally the public, and you shared this with me, that the idea of trademark law, people just have no idea.
Yeah.
And just those basic points that I'm able to share with people, they're like, wow, I had no idea. This is about protecting the consuming public.
Yeah.
Yeah.
It's a little better, right? It sits a little better, right? Because then you're like, it just feels better.
Yeah. And so I'd love to send Catholic brands your way because I know they're in good hands. I know that you have the right approach that is aligned with our faith, and you just have done an amazing job for us. So we're just grateful as well.
I'm grateful for you all. So it's been fun.
No, this is fun. Thank you so much for being our guest. I know. Oh, you're so welcome, everybody. The website is hicksonlaw.com, right?
That's right.
And of course, what?
Oh, I said HIXON.
That's right. Yes, get the mark right.
Yes. So confusion will ensue whether or not you spell it HIXON or HICKSON. So,
okay. HIXON law.com. And of course on Catholic Owned. You're a longtime member as well. So if you have any questions, Susie is absolutely amazing to work with, and she will take care of you. So absolutely don't hesitate to reach out. whether you already have your trademarks, whether you're exploring trademarks, maybe you're working with someone and they kind of fell off. Susie helps with all of those. So,
Yes. Even if you think I want to trademark my idea,
right?
Which is not really a thing, Brooke. You can't trademark an idea, but I hear it all the time. But so if you need like basic, like this is a trademark, this is a copyright, this is a patent, because a lot of times people come to me and their understanding of the three are a little conflated, and that's totally okay. I see that from attorneys all the time. So
yes. So just navigating who to talk to. Exactly. Well, thank you so much, Susie, for being my guest. This was so fun. Thank you to our audience for joining us for this episode of Catholic Owned Live, the show where we talk honestly about faith, work, vocation, and what it really takes to build the new Catholic economy. I'm your host, Brooke Joyner. Thank you so much for joining us, and we will see you next time. God bless you.